Hello, everyone, and welcome to GovCon Roundup Live. I know we got a lot of people that registered for today, and so as people are trickling in, I just want to take a moment to say hello and to thank you for joining us today. I'm Carroll Bernard here with my co-host, Stephen Koprince, and we have a very special guest that we'll be introducing to you very soon. First and foremost, we want to make a legal disclaimer. We do have a current GovCon attorney and a retired GovCon attorney with us today as our guest and our co-host. The information shared during this GovCon live show is for general information only and does not constitute legal advice. Viewers should not act upon this information without seeking professional counsel, and we recommend that you seek that professional counsel from a qualified GovCon attorney on the matters that we're going to be talking about today. We're going to talk about teaming, joint ventures, and the hidden edge in federal contracting. So again, I'd like to welcome back my co-host, Stephen Koprince, as well as our guest, Nicole Patrov. Let's just go ahead and jump right in. So Stephen and Nicole, really, I love this topic. It's one of my favorite topics, and it's one of what I consider probably the most power strategies in terms of government contracting. So I do a lot of market research, and one of the things that I've noticed, a common thread, if we are going to USA Spending or if we are using other market research tools and we're looking at the leaderboards, like if I were to search for any NAICS codes and we see the leaderboards, a very common thing you will see amongst the top contractors is that they either have a joint venture partner or they've got a mentor or they're a protege in this SBA's Mentor-Protégé program, which we're going to touch on today. And oh, by the way, Stephen is also doing a session on this coming up, and I'll share that link to his training next week if you guys want a deeper dive into the SBA's Mentor-Protégé program. But today, you're going to really start to understand how this all works together. So with that, Stephen, let's start with you here. And from your perspective, can you talk about why teaming really is so commonly used in the federal marketplace, but also talk about what it is, because there's various forms of teaming. And of course, we talk a lot when we're doing training with small businesses. We often talk a lot about the ones that are getting started. A really good pathway is to come in as a subcontractor to a prime contractor. Although the federal marketplace is a very unique environment because of the set-aside markets and the small business markets out there. So it's common to see where in one instance, yes, you may be coming in as a subcontractor to a prime, but in another acquisition where you want to go in as the prime and perhaps maybe you're weak in past performance or past experience, and this has been one of the biggest challenges that some of the folks that when we ask our community that they find, but that's not the only challenge. So let's talk about teaming from the other perspective, where a contractor might come in and leverage a larger small business or maybe a larger business that's not small to go in as a win strategy on maybe a larger federal contract that they would ordinarily maybe not have the past performance or experience to win on their own.
There's a lot to unpack there, so let's start with the big picture. What is teaming? What are the common forms of teaming? And then get into that kind of why you do this. And of course, I want to hear from Nicole on these points too, because she's working day in and day out with clients who are doing these exact things. Teaming means partnering with one or more other companies to perform a federal government contract or bid on a federal government contract. And there are really two common forms of it. We don't need to get into any of the arcane stuff, but there are really two common forms of teaming that you see out there in the federal marketplace. One is prime contractor, subcontractor teaming, and the other is joint venturing. And the key differences are when you have a prime subcontractor team, the prime contractor is the only one that has a relationship with the government and is the only one that has a contractual relationship with the government and the only one responsible for the full scope of whatever the work is in the prime contract. The prime contractor then essentially lops off a portion of that work and says, sub, you're responsible for this. You're responsible for your 10% of the work or 15% or whatever the agreement is. To do a portion of it, the sub does not have a relationship with the government directly, is not responsible for performing the rest of the work, just their discrete portion of the work. And everything that you see in subcontracts and prime sub-teaming agreements flows from that hierarchy. It's a one contractor and another one below it, prime sub. Joint venture, you're at the same level. You're equal. Joint venture, I often say, is a legal fiction of sorts that allows two or more, although they're usually two parties, to both be the prime contractor, because that's what a joint venture is. It's typically set up as an unpopulated entity, usually a limited liability company owned by two federal contractors or more, but usually two. And what that means is when the government awards to the joint venture, then both of those entities that own the joint venture are essentially the prime contractor. And so they both, through the joint venture, have a contractual relationship with the government. They're both required to be responsible for the performance of the whole thing. And so if one of the joint venture partners goes belly up, bankrupt, walks off the job, the other's legally responsible for finishing it, et cetera. So that's really what it is. You're talking about a hierarchy type relationship, portion of the contract going to subcontractor, or a relationship more of equals, although not necessarily entirely of equals, because if you're doing it in an SBA joint venture, then there are requirements that might require a certain member of that JV to have more control or ownership of that entity. So those are the big picture of the two most common teaming structures you're going to see in federal contracting. Why do folks do this? For various reasons. So let's start with just your large prime contractors. Why do they do it? Because a lot of times they're required to, because they often, when a large prime contractor wins a contract over a certain dollar value, they're typically required to adopt what's called a small business subcontracting plan, under which then they're required to set goals for subcontracting with small businesses and with various subcategories of small businesses. So they're required. And it can also be baked in as an evaluation factor sometimes on restricted contracts, where you see subcontracting plan goals being evaluated on a comparative basis. So someone who proposes more small business subcontracting might get a higher score on that factor. I've also seen them go back and look at prior achievement, by the way, which is, to me, is even more interesting. Like, how well did you do in meeting your goals on other contracts? So I've seen that for large businesses. For small businesses, it's often a matter of capabilities or past performance. Like, a small business may identify a contract that's going to be a $100 million contract, and the biggest they've ever done is $25 million. And they're like, wow, that's a huge jump. We don't really have the capability to do the whole thing ourselves. We're going to team up with one or more other companies to help us just because of the size. Or there may be a portion of the work that they don't do. It's an architect engineering type job. Here, they're not architects. Okay, we need an architect. They're a general contractor. So they're going to be looking for companies to complement them in terms of their either just the full size of the contract or in terms of the type of work that's required. And so you can put together a solution that's going to pass muster with the government. And then there's often an evaluation piece to it too. Not that if we're going to come into a federal solicitation that's going to have a past performance evaluation factor, which a lot do, they will often say, you have to read the solicitation carefully, and there are a lot of rules around this. We've written, and Nicole has too, whole blog posts, articles on what past performance counts and all this stuff. But oftentimes, the past performance experience of major critical subcontractors counts in the evaluation, and the experience of joint venture, the members of the companies of that joint venture will qualify. And so sometimes you're bringing someone on your team not just because they're going to be necessary at the performance stage, but because it boosts your winning percentage on the evaluation stage. In some cases, maybe you're not even going to be considered for award if you can't present past performance in a certain area or capability in a certain area. So I think that's why a lot of small businesses to chase after and win and successfully perform contracts that they're unable to do on their own. The final reason I would give for why team is to go after contracts as a partner that you're not eligible for due to set-aside status. And so you'll see, for example, there's an 8A set-aside contract opportunity out there. It's this competition. Only 8A certified companies can bid on that thing. If you're a company that does that type of work and you want a piece of that contract, you can't prime it yourself because you're not 8A, but you could participate as a subcontractor or potentially as a joint venture partner. And so it's a way for companies that don't have those certifications on set-aside contracts to still participate in the performance of that contract, even though they're not doing it as the sole prime contractor. Those are my big thoughts on that one.
Thank you. You did a great job summarizing it all. Yeah, teaming is one of the more kind of positive things that we get to do. And does often come up for me where I've helped someone with maybe protests or claims or something, and then they come to me with a mentor-protégé or a JV or even a subcontract. And I say, this is a good opportunity for us to work together on something kind of positive and forward-looking rather than having to argue with the government going back. But I really do think you hit everything on the head. It's an opportunity for smaller, newer businesses to learn and to leverage their status in order to get kind of mentorship and even just partnership from these larger businesses. And it's definitely an opportunity for larger businesses. The only thing I think I'll really add is that of late, with the kind of recent attacks on the 8A program, the multiple 8A companies that have been suspended and even terminated as a result of all of this, several times of late, I've gotten this, what do we do now? And I can tell you the first place I'm going to try to keep the conversation positive and forward moving is, now that you are a graduated 8A firm, let's try to find you a new 8A firm to mentor. That way you can continue working on these 8A contracts you've had for so long. You don't have to just drop everything and never see another 8A dollar. And a lot of them haven't been informed or really had these options put in front of them. So I'm always happy to be the bearer of good news when it comes to things like that. But yeah, I think for the most part, Steve's overview was everything I would have said and more.
While you're on that topic, this is another big reason why you see that firms want a team. There's been some small businesses that's been out there doing really well. Either they maybe are in the 8A program and they're graduating from the 8A program now, so they have like one or two decisions. They could shut their business down, or they could continue. They got three decisions. Just continue on your own using the past experience and past performance that you've built up while you were in the 8A program. That was part of the intent of the program. Or if you don't want to completely lose all of the 8A contracts that you had, like Nicole said, one of the things that was pretty common is that an 8A firm might be looking for new 8A firms. Now, historically, there was this kind of a rule where it was like, once a contract is in the 8A program, it stays in the 8A program. There's been some recent changes to this where now the agency can also take that contract and maybe put it towards SDVOSB, WSB, or Hub Zone, correct? Nicole, do you want to talk about that? And I guess the question is that, could a new strategy for 2026, like, for example, if a firm is graduating from the 8A program, they could look for maybe another 8A contract. Although with some of the challenges right now, could they look for an SDVOSB partner, bring them in, have a partnership to go back into that contract, or WSB? Would you like to talk a little bit about what maybe is different lately with the program?
Yeah. Oh, there's a lot of them. Yeah. I'll keep it pretty brief. And then please, if anyone has questions specific to anything we kind of brush over quickly here, let us know, because we're happy to dig in more. But as Carroll said, we could probably talk about this for an entire session, and we don't need to do that here. Yes, I used to file, not super common, but fairly often, we'd get a once 8A, always 8A. That's the technical name of the rule, protest, which would essentially be, hey, this work has been 8A work. And there was rules for contracting officers. It wasn't impossible to, what we would say, remove something from the 8A program, which, as Carroll mentioned, that doesn't have to be like removed and now it's open and full and open competition. It could be removed for veteran work. It could be removed to the WSB program or just small businesses. And so we used to file those protests on occasion, saying the agency really has two options. You leave it in the 8A program, or you provide a really strong written justification analysis type thing that says why you're removing this. Now, this is going to be a bit of a subjective, and I would love Steve's thoughts on this as well as anything you've heard. But I will say, even when that rule was in place, it was not really enforced too strictly. I had many times where, just based on my understanding of the law, and again, not extensive experience with the rule because we didn't get those protests that often, I would say I've probably worked on maybe 3 or 4 in my lifetime. And every single time I would be talking about the facts, thinking to myself, definitely this is an issue. We can protest. They did something wrong here. And in reality, I felt like we had smoking guns on a couple of those, and we still didn't really get, I don't think I've ever really just completely won one. We might have had an agency willing to work with us a little bit, but not so much GAO or anybody saying, yes, this is a win. So I don't think the change is huge in reality. I think it's pretty huge on paper, though. And I believe it would have been like late 2025 with this revolutionary FAR overhaul stuff that the rule is just no longer written. It is no longer a thing. I do think that based on some of the underlying statutory goals, the 5% goaling for the disadvantaged businesses and things like that, I think I'm seeing less work just being pulled from the 8A program than I thought I would see. And maybe we're going to see more of that in the future. But I still have a healthy amount of people coming to me asking about the 8A program, wanting to get into the 8A program. And in my experience, that's not just because contractors are out there bored wanting something else to do. Typically, a lot of times if the partner business says, hey, if you were 8A, I could give you this. Or an agency even says, we really need to issue this new work in the 8A program. If you can get your 8A status, we can give you this work. And so I still do have a lot of people coming to me, but just to finish sum up my thoughts here, as Carroll also mentioned, I think the service disabled veteran program and veteran program is very much alive. And maybe I'm still a little bit delusional. I'm still not at a place where I'm ready to give up the 8A program and tell people like, don't worry about it anymore. Don't bother trying to get into it. I still think it's a thing. And I hope for some positive change potentially down the line, keeping it in place. I think it's going to continue changing and evolving. But when people come to me and say, look, I might be eligible for WSB, SDVOSB, 8A, whatever else, I am going to tell them at this point in time, let's get the SDVOSB and the WSB in place. If you're hub zone eligible, let's get that in place. And it's not that I think those programs are totally safe. It's that I think as of now, we are starting to see, and maybe not as many agencies pulling work from the 8A program, but as you'll see from most of those rules, if a contract is changed a certain amount, or even depending on where it's resolicited, sometimes there's some allowances for agencies to pull things from the 8A program and resolicit them through a schedule or another BPA or something, to where the rules actually end up being a little bit less severe. And as you probably have talked about with the FAR overhaul, some of the GSA schedule changes are actually to lighten up restrictions on the agencies and allow them to do things much more quickly and efficiently with less red tape. So yeah, I think the focus on the other programs is really good right now. And I think especially if you're already in the 8A program, there's nothing I would say just give up and throw your cards in or anything, but might be a good time to think about things like teaming up with another company, maybe an SDVOSB, maybe a WSB, because you can talk to them. One thing I'll say real quickly, because people ask me this all the time, if I'm an 8A and I want to team up with a WSB, can we just do one joint venture that allows us to go after 8A and WSB work? And I've always wanted to say yes, and you cannot say yes to that. The answer is no. The answer is, I guess, that you could, but we would not advise it. And the reason is the rules are strictly written in a way that, and I think I take this all the way back to some of the first webinars I was ever on with Steve and him saying this as well, honestly. But the flip-flopping of ownership and management is not something we would ever really recommend. And that's both from just a business perspective and a federal regulatory perspective, confusion and contracts like that. So something you can do, and we could probably talk more about today, is having a scenario where you set up multiple joint ventures with the same company, having an agreement where you all know the kind of work you're going to go after. If that happens to be issued as 8A, you use joint venture number one that is an 8A joint venture. Happens to come out, now that this rule is not in place anymore, as an SDVOSB, hub zone, WSB, one of those, then you would use the other joint venture where that managing venture qualifies for those statuses. So
that was amazing. So I want to sum up something right here. And this is why, from what you guys have just heard, I always recommend that if you are looking at doing a teaming, structured joint venture, or SBA Mentor-Protégé program, go and work with a really good GovCon attorney that really knows this stuff, because the first meeting that you have with them is that they'll tell you what you can do and what you can't do, and then probably will have some recommendations for you that could be maybe better than the idea you maybe came up with before, because you don't always have to go straight into a joint venture maybe to get some of the experience and past performance that you need to win the contract. So let's step back a little bit, because I want to make sure that everybody understands the benefits and the purposes of the structures here and the different kinds that you can use. So let's go back like circa 2012, Stephen. This is when you and I started working together. And at that time, I had just launched our business, and I was working as a consultant, and I was a training coordinator for a grantee that received an award under this pilot program that the SBA had at the time called the Small Business Teaming Pilot Program. And the purpose and the goal of this program was to put two or more small business together to be able to get contracts that were over half the size standard of the NAICS code at the time. That was the weird way that it was written, and it was very challenging to just find two small businesses to do that. But I had a couple of aha moments out of that, and specifically why you may use a teaming or a JV structure over a teaming structure. So first and foremost, when you are looking at the evaluation criteria in the contract, typically under Section M, that's where you're going to see what type of past experience and past performance the government is looking for. So if you're very weak on those elements, now you start thinking, can one of my subcontractors that are maybe larger and more experienced loan their experience and past performance to me inside of this particular acquisition? Now, if you read carefully inside of that, sometimes the agency will say your subcontractor's past experience and past performance can count. If it says that, then you can maybe simply get a letter of commitment, or you'll do like a written teaming agreement with that particular contractor that you maybe leverage an attorney to help you write up to make sure you've got all your I's dotted and your T's crossed. But the solicitation may not say anything about it. So that's always a good question to ask. If you're at the solicitation phase, will you accept my partner's experience? And if they say no, we want the experience held within the prime, that is when you really start to look at JV structures. And this was one of the aha moments for me. And this is one of the reasons why the grantee had a very hard time helping contractors with JVs, because you really can't start putting the joint venture together, and especially if you're going to get into the mentor-protege program once the solicitation drops. This is why in a lot of our training that we do, we really talk a lot about forecasting, so you can see opportunities ahead of time, and then you build your strategy. You could look at the historical solicitations to see what did the agency show in there the last time. Did they accept teaming? Did they allow subcontractor without a joint venture, et cetera, et cetera? But what I learned during the program is that when I would call into the agencies trying to understand what their philosophy was on teaming for an upcoming opportunity, they wouldn't tell me. So what is your best bet? Which gives you the most strength to really make sure that the agency is going to count the experience and past performance of your prime? It's the joint venture structure. And if you have time to put it in place, you do it. If you want to partner up with a larger partner, you can only do that through the SBA's Mentor-Protégé program, because it gives you a special exception from affiliation. But Stephen, let's go to you now. All of this stuff I just said, can you talk a little bit about that from your perspective? Am I on point here with kind of the logistics of how these decisions and these strategies kind of work from a most basic level?
Yeah, I think that's right. I want to highlight a few things just to summarize some of the key points there. The first things first, a lot of folks assume that the FAR mandates the past performance of a subcontractors be considered. It absolutely does not. And so if you go to FAR Part 15 for negotiated acquisitions, that's usually the rule book's going to be FAR Part 15 typically, and says the agency should consider the past performance experience of subcontractors that will play a significant or major critical role in the project. And so should, as the GAO and Court of Federal Claims have held over the years, is a specific choice of words. It's not shall, it's not must, it's should. And so if the agency should do it but still decides not to, they're within their rights to do that. And so that's why you will sometimes see acquisitions that say experience must be within the prime contractor, or that we'll consider sub-experience, but we're only going to consider it at 50% weight of what we're giving the prime contractor experience, or commensurate with the scope of work of the subcontractor. If they're only doing 10% of the project, then we're not going to treat their experience like it's as valuable as the companies that's doing 90% of the project. So there are a lot of rules in their solicitation based. You go to that section M if it's following the standard format of the solicitation. That's where the evaluation factors are, and you see what the agency says about subcontractor past performance. And if they are silent, that's a great question for a Q&A. If they don't offer a Q&A session, still reach out to the folks, points of contact. There's nothing wrong with saying, hey, we just want to ask you a question about your solicitation. Will you consider my subcontractor's past performance? Because if you bid under the assumption that it will be considered at the same weight as prime, and the solicitation is totally silent, you're taking a risk. You're taking a risk as to what's going to happen with that. But you're also right to say that you don't necessarily have the time, depending on your situation, to put together a compliant joint venture if the answer is no, if you don't like what's in the solicitation. Sometimes you will, sometimes you won't. And so another common misconception is that two small businesses must have a mentor-protege agreement to do a joint venture. You do not have to do it. The relationship between mentor-protege and joint venture is essentially that it allows a large business and small business to team for a small business set-aside contract or some subspecies of that, like 8A, like SBA.
Specifically to joint venture, right?
Specifically to joint venture, right? Yeah. It can be a subcontractor. A large can already be a subcontractor, but to be a joint venture partner on a small business set-aside or subcategory of small business set-aside contract, the joint venture has to have a mentor-protege agreement in place, an active mentor-protege agreement in place, active SBA-approved mentor-protege agreement in place. If two small businesses, both small under the NAICS code assigned to that solicitation, want to form a joint venture, they don't need a mentor-protege agreement to do that. They can just proceed straight to the joint venture. There's no prior approvals of that needed. So that can be done pretty quickly. You're probably setting up an LLC in your state, working with an attorney to get a good JV agreement together, you're done. But if you have to go the mentor-protege route, now you've got to build that into your acquisition plan. because the SBA's website itself says expect 105 days for a mentor-protégé agreement to be processed. That's what SBA's website currently says. I just checked it yesterday when I was updating our session I'm doing next week. And they still say that. And so it could be shorter than that, could be longer than that. But until that mentor-protégé agreement is approved, a joint venture that contains a large business is ineligible to pursue any sort of small business set-aside contract. So if that's going to be your backup strategy, you're going to have to form that joint venture early. And you can do it even if you're not planning to use it, unless it's a backup. There's not a lot that goes into it. You're going to probably pay an attorney. You should get an attorney like Nicole or somebody in that world to work on a compliant joint venture agreement, because they are really tricky and complicated. And even the rules for a joint venture agreement between going after a small business set aside and an SUSB set aside are different in some cases. So do that, and you've got to form something with the state government, get the SAM, all that stuff, but nothing crazy. And then you can sit there, and that joint venture agreement to sit there, and you've probably heard about this kind of limit, 2-year rule limit for joint ventures. And we don't need to talk about that here, except to say that the 2-year clock doesn't start ticking until it wins its first award. So if you form a joint venture today and just don't have it just sitting there until you need it, which may be next year, you're fine. That 2-year clock hasn't started ticking, and you can just have that as a backup. It's just sitting there waiting for you for when you need it, for when that situation comes up. So all that is to say, there's a lot going on there between picking the right team, but I have been part of cases in which the prime sub route appeared late in the game to be the wrong approach, and it was too late to do the joint venture route because of that mentor-protégé time frame for approval, which could be 4 months. So it's just something to keep in mind.
Yeah, definitely. Forecasting is important if you can get that done. Nicole, let's come back to you. So let's just say, what advice would you give to contractors out there that understand the teaming strategies that we're talking about here today and the power behind them, and they want to leverage this? I want to caution contractors to be very careful before you go and start having even discussions maybe with teaming partners or joint venture partners. Or Stephen just said it takes 105 days to get into the SBA's Mentor-Protégé program. So if your strategy is like, hey, we're going to use this large firm to get in there and have a JV, and maybe even if you forecast it and the solicitation is 90 days out, likely you're not going to get everything done in time. Stephen mentioned how you don't have to do the Mentor-Protégé program if you are partnered up with a larger small. And there's some really awesome small contractors at $20-30 million range. I like to make that recommendation often to folks. Go and partner with them, because a lot of times also, not only are some of those 8A programs graduating out of the contracts, but you also have, and what we also see a lot of is contractors, small business contractors that have done, they're getting close to maybe sizing out. Maybe they haven't yet, or they would be still small in some NAICS codes, I guess. So I guess, Nicole, if you're giving advice or suggestions, we're not giving legal advice today.
Right.
That's definitely where you guys would want to have a one-on-one with Nicole. But I guess, what should people know as they start having conversations with other partners about potentially teaming up under a specific acquisition that they want to pursue together? Do they come to you first and get a little bit of a game plan before they go starting to suggest what they're going to want to do with this prime contractor? Because you could basically have a lot of conversations, and then all of a sudden, oh, we just talked to our attorney, that won't work. Or worst case scenario, you don't talk to an attorney and you figure out it won't work. So what considerations would you give folks as they're maybe thinking about partnerships before they even come to a conversation with you?
Yeah, it's a great question. And I think Steve and I together once did a 3-part biology webinar strictly on teaming. And there's not a lot of subject matter I think we could really get 3 full parts of, and teaming is one of them. And it's for this reason. Steve made one really good point, lots of good points, but the one that I'm latching onto here about mentor-protégé agreements taking a while. But I will even say, where you don't need a mentor-protégé agreement, I've even had scenarios where clients have come to me a little too late in the game, figuring out maybe the prime sub relationship is not the way to go for this one. A lot of times that is based on things like, oh, I guess they're not going to count my sub's experience, and they really don't have to. There's nothing that's forcing them to do so. If we did a joint venture for both small businesses, then they ideally have to consider both venturers' past performance. Now, how they have to consider it, that's still up in the air and has been a subject of debate for a really long time, because the rules, although they seem you could make the case that they're clear on either side, but they're obviously not, because we have some agencies saying where the mentor-protege underlies the JV, there's additional requirements on what an agency can say the protege has to do. But when it comes to just regular old joint ventures, and I think the 8A program is the one kind of exception here, but there is quite a bit the agency can say about how much of the experience they're going to consider. Just because they have to consider both does not mean they can't say, yeah, we still want to see several examples from both or something along those lines. So even with joint ventures, the problem is you have to be registered in SAM prior to bidding for most of these awards. And even that can take weeks to get done. So knowing early in the game which of those considerations you really need to have in mind moving forward. And I think, again, before you talk to another company is probably the best way to do it. I think of my clients that I think are really doing it right, they have come to us at some point where something wasn't immediately on the line, and they said, let's have a call, let's do a memo, let's do pretty detailed analysis of here's the type of solicitations we bid, what do we need to know about teaming under these solicitations? And that's where we can go through things like, what are they allowing for past performance? Are there special rules? Is it even the limitation on subcontracting, or are you allowed to use the non-manufacturer rule for this one? Or what are the limitations and how are those going to apply? Knowing all of that ahead of time, I think, is really important, because as Steve said, you can decide last minute to do a subcontract, and you can decide after an award to do a subcontract. Typically, you do a teaming agreement first. And I think one of the biggest takeaways as far as what would I suggest is really making sure that your teaming agreements have a lot of these things covered and have a lot more certainty in them than your traditional teaming agreement may appear. Or if you were to go pull one off LegalZoom or something, typically you want to see stuff in there that puts both parties on notice and makes things really fair, and you know what to expect. Are you going to be guaranteed a subcontract? Are you guaranteeing a subcontract? Things like that. That's really important, and that's not something you want to be working out last minute. When it comes to the JV and the mentor-protege JV, it's typically not something you can work out last minute. So if you decide last minute, and I guess to clarify that a little, even if you know you want to work with a partner, you believe all kinds of information about the limitation on subcontracting and the past performance, as Carroll mentioned, you could have somebody that's on the line and small for some things and not small for others. You could realize last minute, oh, wait, we can't do just a joint venture with you because you are actually not small under this NAICS code for this contract. You are small under some, but not this one. Those are just really good things to have knowledge of and have in mind ahead of time. I also think the more prepared, and this is more a message for some of those smaller businesses, the more prepared you are with information going into these potential partner meetings and potential contract negotiations, the easier it is for you to stand your ground. I think there is a shocking amount of, not to pick on the larger businesses, but businesses out there that have been doing things in violation, whether knowingly or negligently, or even really have no idea, but violating some of these non-manufacturer and limitation on subcontracting rules. And a lot of times you have a conversation with them and you're not standing firm in your, this is how this work would have to work based on the contract value, based on the limitation on subcontracting, based on your size, my size, etc. If you go in wishy-washy on any of those things, don't be surprised if that large business says, no, this is the way it is and it works this way and our lawyer says it's fine. Legally, we haven't gotten any trouble and we've been doing it this way for forever. And that doesn't mean it's compliant, and they're much more likely to steamroll and end up convincing you something is compliant that is not compliant. So I like having small businesses really having that policy in place. It is well worth it, even if you can budget something in, be it some of the training through Govology, be it extra conversations with your Apex, your SBA rep, and then especially if you can have an attorney do an actual analysis of the type of work you go after, the NAICS code, what the past performance limitations of your solicitations seem to be, and what kind of rules you need to keep in mind for subcontracting and joint ventures. I think knowing all of that ahead of time and being able to almost recycle it every time you have a conversation, you can also weed out some of those partners much more quickly. I have clients come to me and say, I got a conversation, I even had you start on a contract, but after talking to this company for 10 minutes, I realized they have no idea what these limitations are or how they apply. They are not wanting to abide by them. Their idea violates them. Because I already have that knowledge, I could weed that out, not waste my time, and then not end up on the wrong end of one of these audits, contract investigations, even False Claims Act, and more severe consequences that can follow.
Can I just jump in on something really fast here? Because Nicole hit on these limitations on subcontracting, which I think is really critical.
Stephen loves that topic.
Yeah, we're not going to get into that, but I just want to hit on, because you've been seeing, I'm sure a lot of folks on this session have been seeing out there this push by certain folks toward this middleman approach, which is the idea of just winning government contracts and just hiring someone else to do all the work and then sitting on a beach and sipping margaritas and watching the money roll in. And it doesn't work that way for many reasons, but in particular, because in a lot of contracts, most small business set-aside contracts or anything involving some sort of certification like 8A, there are going to be limitations on how much of that work you're allowed to subcontract. I've seen YouTube videos where someone's up there saying, just get a small business set-aside, then find large business and sub all the work. And I'm like, unless it's under the simplified acquisition threshold or it's a non-manufacturer rule, there's some exceptions here, but they don't get into that. They're just like, oh, here's a $5 million contract and you just sub out all $5 million. I'm like, no, you could do that, but you could end up in jail. Don't do that. False Claims Act, stuff like that. So just for folks who are thinking about teaming in the sense of, I'm just going to find someone else to do all the work, first ask yourself, if that was really a thing, wouldn't everyone be doing that? Why would anyone do the work? Like, everyone would just want to be the one passing it through for free money. But keep in mind that while there are scenarios where you can essentially be a sort of middleman, not in the way maybe some folks pitch it, because you still have that contractual obligation of government, those situations are much more limited than people think. And limitation on subcontracting is a major reason why.
All right. As I was listening to you talk, Nicole, I was actually thinking how valuable the services that you guys provide are to contractors, because I think, like, in a lot of terms, people think about attorneys like when they need a protest or when they just need a review of an operating agreement or some paperwork drill. But really what you provide is compliance strategy consulting services in a way, because you're really talking with your clients about all of these things like ahead of time. So now they know when they go in to start having conversations with partners, they've already got a compliance strategy that partners either going to buy into or they're not. And I also like what you said, and I also talk about this a lot, about the value of leveraging and having an attorney on your side, is because we see a lot of these contractors that have been out there for a while and they're like, hey, we've got a teaming agreement, and they'll just email you a teaming agreement, or maybe they've done their own joint venture agreements before, go ahead and sign it. But number one, that might not be up to date to current rules. And number two, it may not have protections built in for you, which is very important as well.
Yeah, I think that's vital. If I can touch on that for just a second too. I like the point that you made about signing it and then maybe having an issue after the fact. The really unfortunate thing for what we do, and frankly, most of the firms that specialize in what we do, is if you are out there just grabbing whatever contract, taking some large business's contract and saying, they sound like they're looking out for our best interest here, and signing it, even a joint venture where most of it should be straight from the regulations, just signing it without someone protecting your rights and looking at your side of things. At that point in time, there's often we can't help. I've had some of my absolute clients I love and would love to help come to me and say, we signed this contract a ways back and now here's the issue, and I'm having an issue with my partner, but under federal law and under the prime contract, I would love to help you with that. Yes, there's an access to the prime contract, but there is only so much I can do. Even if the answer from me is, look, under federal law, you were supposed to have this in there, it still becomes a state law issue and you end up in a state law dispute vast majority of the time, which I can no longer help you with. So I beg and plead my clients, and really anytime a client comes to me with any kind of dispute regarding a contract that I did not initially look at, which is not always their fault. Sometimes they had other counsel, and this is another place where I'm not trying to knock the large firms or the large businesses, but I cannot tell you how many times I've gone, we'll say up against, but as far as just working on an agreement, and the other side is an attorney that is 3 times my age, been practicing for a really long time, and they work at some huge famous firm, but that firm does something that dabbles in federal contracting rather than being a federal contracting firm. And I've had times just mind-blowing where I've had to sit and negotiate things, and just pointing directly to where things they're trying to put in the agreement are fully outlawed by the federal regulations. Or a big one is where you have your joint ventures and even your prime and sub relationships where there is a set aside that only the prime or only the managing venture qualifies for. The way the rules are written, the amount of kind of managerial control and control over proposals and contract performance and all kinds of things that are required from everything from the limitation on subcontracting, also the affiliation regulations, so you don't end up with an ostensible subcontractor or an improper joint venture regs, even the mentor-protégé regs. All of those have a common thread where there's a certain amount of ownership and control that is just must be held by the qualifying entity. And the times that I've had contractors speak with their bigwig attorneys and come back to me saying, we're never going to agree to this. You absolutely have to if you want your hands on the set-aside money. And it happens a lot. And I think, again, going back to things that Steve, if anyone is unaware, Steve was absolutely my mentor, and I've learned a ton from him. And I feel like even my ability to do a good, solid, interesting webinar stems from the ones I've done with Steve. But from the beginning of time, we would do the different common mistakes that contractors make. And one of those has always been going to be taking an agreement that a large business or even just a larger small business hands you and says, our legal wrote it, it's compliant with the rules, just sign it. And people do get in this weird understanding that they may just need to sign things. And I think part of that comes from our just general country's reliance on these like adhesion contracts, where if you want your Apple phone, you got to sign something. If you want to go to the theme park, you're ideally signing something just by buying your bracelet, or you're giving certain liability, all that good stuff away. So I think people do get under the impression that they just have to sign these things. And even where I have a lot of clients that have done nothing but prime contracting, they're used to getting the contract from the federal government where, you know, yes, it incorporates parts of what you proposed in your proposal, but again, that's not really something you negotiate. You don't generally hand back a prime contract and say, I don't like any of these flow downs, I want to change them. So people get in this mindset where that's a bad thing, or that's a controversial or adversarial thing, or that's going to chase away a partner. Frankly, that chases your partner away. That is not a partner you wanted in the first place. And having an attorney that you trust to catch those things, but also do so respectfully. I've made really good friends, contacts, etc., with other attorneys where they were same. We were all trying to follow the rules, trying to protect our clients' needs. We've gotten really good over the years at this term is necessary to protect our needs, but here's a way we can modify it just to make sure that it maximizes both sides' protections. So I think biggest takeaway from all of this is even if you think you've got one attorney representing everybody, and this is why we don't represent a prime and a subcontractor on an agreement. I will say there's some rare conditions with conflict waivers and things where we can represent a JV generally, and we can draft a JV. That's because the joint venture is highly regulatory, and we would still absolutely advise the parties each have their own private representation to protect their rights. But we would never represent a prime and a sub because there's so much flexibility there, and so much more of it is a right to contract. So making sure that you have an attorney at a very minimum that looks at your contracts before you sign them, at a maximum, best case, that helps you draft up templates that you provide. Yes, it may be cheaper to take someone else that you all provide the template, will modify it and send it back. In the end, I really don't think that ends up being cheaper for my clients. I think them having a good set template, rules going in, and again, to reiterate what Carroll said too, it gives you the leverage. It allows you to stand your ground. If you go in knowing right off the bat that, hey, no, we can't be flexible on these things. So if this is a deal breaker for you, then deal is broken.
Yeah, there's other
I
partners
just
out
add
there.
one thing to that, just perfect point, Nicole. And I think that we've had these conversations many times, and I appreciate the nice things you said about the mentoring too. But you have to have the right mentee to make it work well. So thank you for everything you've done. There is this mindset also, I think, among some small businesses, particularly, that when a large company hands you something, that it's going to be perfect because they're large and they know what they're doing. And sometimes it's pretty close to that, but a lot of times it's not. And one of the ones that the quickest way for me to see on a lot of these contracts, when my client was a small business subcontractor to a large prime under a subcontracting plan, was to see if the large prime had put a NAICS code and size standard in the subcontract. Because they're required to do that, right? Both under the FAR and under the SBA's regulations. The NAICS code doesn't flow down automatically from the prime contract to the subcontract. It's a very common misconception. In my experience, the vast minority of contracts actually include that flow down. So there'd be something like you certify that you're a small business, and if you get the certification wrong, then you give us your firstborn child in payment or whatever. Something really crazy, but they wouldn't tell us what the size standard was because they assumed it flowed down. At that point, I'm like, okay, they missed that. They probably missed some other stuff.
And it's crucial.
Yeah, it's crucial. You have to know what you're certifying against. So you can't just, a small business size standard could be $7 million. It could be 1,500 employees. There's a huge universe out there. So once I didn't see that in there, I'm like, okay, we're going to have to pay a little more attention to this one because I didn't get that one. And that was it's probably a quarter of them that I saw that had that in there, and the rest of them.
What is it? I think it's the similarly situated language also. People don't realize this because they very often go to look at the status of the NAICS code assigned to the prime contract and just assume that's what everything is based on. But there's actually regulations strictly based on what NAICS code is assigned to the subcontract. So not having that in there is a good way to realize maybe you're dealing with someone that doesn't have as much experience, but B, it could hugely impact your eligibility for things.
Wow, that's a lot to take in there.
It's a big topic. And then Cole said we did a 3-part series. We probably could have made it a 10-part
I
series.
think, we got to get that one going again, by the way. One last question that I've got for you guys here. With relation to the joint venture, what the agency will accept, what they won't accept. So we've seen some changes to this over the years, and it looked like at one point there was like some rules where the SBA said the agency kind of must consider both the partner's experience, and then there was a rule change that said the agencies can require some experience. Can you talk a little bit about that? But also, I got a little confusion over a specific VAR clause that I saw. I'm like, when did that come into the VAR? I must have missed it, but it was something to that effect as well, that in the VAR it says that like a SDVOSJ for the VA contracting, if there's an SDVOSB joint venture, they have to accept both parties' experience. Is there some restriction on, or if somebody's coming in with no experience? And the reason why I ask is because we see people like this, that they'll come in under one NAICS code, maybe pivot under another NAICS code, have no experience. Can people that don't have any experience form a joint venture under these kind of circumstances to have pretty much all the past performance and experience held by their joint venture partner? And so there's the normal scenario, and then there's the scenario with what's in now the VAR.
Yeah, so I can at least address the first part of that because I just wrote an article on this subject not long ago. And so the rules have changed on that a lot over the years. And the question being, when you have a joint venture, specifically a mentor-protégé joint venture, what are the rules regarding the extent to which the agency can require the protégé to have experience? Can the agency do that? Can they require the protégé to have past performance and experience? Can the agency just let the mentor's experience cover everything? Because a lot of these solicitations, particularly the bigger ones that a lot of these JVs are going after, like we want 5 recent relevant past performance projects with a certain dollar value, certain scope. And a lot of times the protégé member doesn't have that. It's gone through several iterations, the rule. Where we've landed is that first things first, in that mentor-protégé joint venture situation, the agency cannot require the protégé to have the same level of experience as would if it was bidding alone, and the same level of experience in past performance as if it was bidding alone. In other words, if the solicitation says 5 recent relevant past performance projects, the agency can't say, protégé, we need them all to be from you. They can't do that. But they can require some lesser degree, so probably would be reasonable for the agency to say we need 2 of them at least to be from the project if they want to. Or alternatively, under the current rule, and this is recently confirmed in a GAO decision, the agency can let all the mentor's experience cover the whole thing. And the agency can decide for this particular solicitation, we're fine if all 5, in my example, past performance projects come from the mentor. So that is another case where it's Section M. You got to read the solicitation and understand what the requirements are, because if you're the protégé member of that joint venture, you may be required to present some level of past performance experience, though not necessarily or shouldn't be the same amount as if you were bidding it by yourself. Or the agency may just let you lean on your mentor completely. So basically we're in a world where it's agency discretion, it's solicitation by solicitation. You can form a joint venture and in hopes that you can rely on your mentor's experience, but you may not be able to do that in every case. It's going to be case specific, and that's where the rules are with respect to that right now. That was a GAO case I wrote about on my Launchpad blog. It was published March 31st, so just a couple of weeks ago I wrote about that GAO case.
Yeah, that was an interesting one.
Yeah.
Nicole, I was going to actually turn to you and ask you if you have any insight on that VAR clause that's in there.
I'm going to specifically pull that one up.
Provision.
It's interesting, as you've said, there's been a lot of changes. That I think the general trend is that it started with a vague assertion. The idea initially was you can't require a joint venture itself, the entity, which is, again, as Steve said, usually a separate LLC that's formed, not always, but most of the time. You can't require that entity to have the same past performance as everyone else in the competition. You have to allow the joint venture partners in the aggregate to have that. But then over the years, until the rules, which the rules are much more specific now, but they started vague, so it was all about the case law. We would go back and forth on where an agency allowed this, was it okay, allowed this one is okay. But I think the trend there and the trend even in the new more specific regulations, just like Steve pointed out, is it is that agency discretion. And this really, to me, comes full circle to what we were talking about a little bit ago, which is timing. And when you think you're going to need a partner for some kind of solicitation, at what point in time do you want to talk to an attorney? And the answer for this very reason is very early on. Do you want to understand all of this? Not every solicitation specifies. And if it doesn't, this is one of those areas where I do not advise relying on a potential like kind of default. You really want to know what they're going to consider prior to you even considering who you're going to team with and how, and asking that. You'll see a lot of Q&As where the subject matter is about past performance experience, things like that. It's really important to know early on and have it in writing and make sure it is a part of the solicitation, because you could be thinking you're coming in with this great past performance. And as Steve said, just because it says you can't have the protege or 8A partner, whatever, to a joint venture, you can't require them to do something that everyone else. It could be that there's 10 references required, and that's a lot, but they say the protege needs 9. And so you could be essentially in almost the same boat and still have them complying with the rules by not having it be the same amount. I want to pull up, Steve, do you know exactly which VAR clause?
I don't know exactly which one. I know that there's a deviation out there for VAR for joint ventures for SBA, because what the deviation does is essentially the VAR used to require that the joint venture itself be listed in that VIP
certified
system, and they deleted that, I think, in 2023. There is a provision, and the only one I can think of that's different for VAR off the top of my head is there is a provision in the VAR that requires any SDVOSB, not just the joint venture, but the joint venture too, to be eligible both at the time of bid and as award as a joint. There's recently a case out there too. Usually your status is just determined at the time of bid because you don't control the date of award. And so if you're going to grow next year, it's December, you submit your proposal, you're good. You don't know how long the agency is going to take to award that contract. We've seen awards 2 years after the solicitation comes out sometimes. But the VA's clause for VAR does say that for joint ventures too, must be eligible as an SDVOSB both at the date of bid and as of award. But other than that, I'm not sure which one you were getting at there, Carroll.
Yeah, we don't have to go deep into that one. It was just something that I came across, and I'm like, oh.
We'll have to talk about that offline. Maybe we can bring it up in our
maybe that's
in July.
Yeah, that would be a good one, actually. We could revisit that in July. Yeah. So let's go ahead and get it in. All righty. Also, the other thing that I want to mention here is I'm going to repost some of the links published for Stephen's FedLift Substack, as well as how to connect with us on LinkedIn. So I'll post that again. Also, I want to give a little plug for our Procurement Readiness Academy that we run here at Govology in partnerships with some of our Apex accelerators. We're about to kick off another one on Friday. I'll put a link for those of you guys who want to join it. But we talk extensively about really doing that market research. We've got a lot of topics, but we really talk a lot about the market research and forecasting and really getting in front of this. And one of the webinars that Stephen does on teaming is part of that learning pathway. I highly suggest that one for you guys. With that, again, thank you, Nicole. And also, again, thank you, guys, for sponsoring this show. We really appreciate it. For now, we'll close out. Again, we're going to have our next session of GovCon Roundup Live in July. We're going to be talking about VOSB and SDVOSB programs. We'll have that soon for you guys to sign up for it. Again, that link is just govology.com/roundup. Nicole, I invite you to join that one again with us. I think it's going to be on July 15th.
All right. I will chat with Shane, but I love that idea. And yes, we value you all in our partnership an awful lot. So thank you so much for having me today. And as always, you've got a fantastic group of attendees. And I know Carroll already stressed this once, but anybody with follow-up questions, I see a couple others in the chat, please feel free to email me or the group and we'll answer what we can. So
yes, and thank you guys as well for being with us today. So we'll see you again soon. Take care.
Bye. Thanks.